a place called home. We've come home, we've come home to a land of our own. After 2,000 years, we are home. זאת ארצי מולדתי, על אדמתי שרדתי, עברי עתיד.
I love these guys. That's Israeli a cappella singing group Kipa Live singing their song We Are Home, which is about Jews who come home to Israel, make Aliyah and move to Israel, as several members of that group have done. Let's light up the darkness. Who's in the house on a Friday? Yom Shishi. Yehudit in South Carolina, Bill in mid-Missouri, Sharon in New Jersey, Renee in Indiana, Paula in the Great Northwest. Paula says Shabbat Shalom. John checking in from Scotland. And Gordo from Scotland. Colleen in Speyer, Germany. Jerusalem on the Rhine. Wonderful. James in Indianapolis. Belle in Texas. Patrice in Utah. Lynn in Maryland. Marie in Freeport. Welcome, everybody. Great to have you with us. How about a shofar blast before Shabbos? Our daf today is page 26 here in Tractate Kiddushin, the 20th volume of the Talmud. We're working our way through chapter 1, today beginning with Mishna number 5. We've been talking about modes of acquisition in this tractate. It's about betrothal, but betrothal is understood legally as acquisition, right? So the husband-to-be acquires the wife-to-be for betrothal, as we learn through exchange of money, through a document, other means as well. And once we got that into acquisition, we learned about the acquisition of a Hebrew slave and then a Canaanite slave, and then livestock, and then we continue this idea of being kone, something, acquiring it, right? That's the way, Hebrew is such a syntactically interesting language. When you are going to properly translate, I acquire something, right? You would say, to be kone it, right? To be the acquirer of it. So now we're in mission number 5. We're going to be talking about acquiring property and making a distinction between the acquisition of real property, land, and movable property. All right, right near the top of page 26a, Mishnah number 5. Property that serves as a guarantee, which means real property. Land can serve as a guarantee. Movable property does not. But also, it's not just real property. It can be other items that are fixed in the earth. Interesting. So property that serves as a guarantee can be acquired by means of giving money, by means of giving a document, or by means of taking possession of it. Property that does not serve as a guarantee, i.e. movable property, can be acquired only by pulling. Property that does not serve as a guarantee can be acquired along with property that serves as a guarantee by means of giving money, by means of giving a document, or by means of taking possession of them. The movable property is transferred to the buyer's possession when it is purchased together with the land by means of an act of acquisition performed on the land. So a question that the sages will, immediately ask in our discussion of this Mishnah: does the movable property, which is going to be transferred along with the real property, need to be on the real property, or can they be bundled together even though the movable property is not on the real property? Stay tuned for that question. Now, continuing the Mishnah, generally one is not obligated to take an oath concerning the denial of a claim with regard to land. So the Mishnah continues, and in a legal dispute involving both land and movable property, if the defendant makes a partial admission of the claim with regard to the movable property, right, he might say, well, John is bringing me to court and he's suing me, saying that he, paid me all this money and did not receive the deed to the land and the movable goods that I said were also part of the deal. So I could say, he paid me the money, but the deal was just for the movable goods, not for the land, right? So that's a partial admission. So when there's a partial admission, in certain cases and situations, somebody like me who's making a partial admission would have to take an oath that I am telling the truth, that yes, I owe him this part, but we never made a deal for that other part, right? That would be an oath in such a situation. So in a legal dispute involving both land and movable property, if the defendant makes a partial admission of the claim with regard to the movable property, thereby rendering himself obligated to take an oath denying any responsibility for the remaining property, the movable property binds the property that serves as a guarantee, meaning the land, so that the defendant is forced to take an oath concerning the land as well, despite the fact that one is generally not obligated to take an oath for a claim involving land. Why would you generally not be obligated to take an oath for a case involving land? Because the transfer of land tends to be much better documented, right? So that we're not going to have an absence of evidence such that the partial admission is going to be received as evidence, and then when coupled with an oath that I admit that, but not the rest, then I could be believed on the basis of that oath, right? This was, again, in a society where people were more pious, perhaps, and it's enough. Like people wouldn't, people wouldn't make an oath lightly. These days I wonder. I mean, thank God I haven't been in a court case, at least not anytime recently that I can remember. But I mean, do people still swear on a Bible that they're going to tell the truth, the whole truth, and nothing but the truth? I'm pretty sure they have an option not to do that. But when a society was sort of, faith was a bigger part of society, not just in the ancient world, but I mean, even in the 20th century, I think people would be much more reticent to take an oath like that and lie about it than perhaps they are today. I can't speak for other people, but it just does seem like the societal level of piety has dropped, sadly. But at any rate, when we're talking about rabbinic law and Torah law, this partial admission coupled with an oath was understood to be strong evidence in a case. Let's just put it that way. Okay, we move on. That was Mishnah number 5. Here's the Gemara. The Gemara inquires, from where do we derive that land can be acquired by means of money? Well, Chizkiah, the sage Chizkiah, said that the verse states, Jeremiah 32:44, they shall acquire fields with money, right there in the Bible. So the Gemara asks, but if the proof is from that verse, one can say that the acquisition is not valid unless there is a document as well, as it is written in the same verse, Jeremiah 32:44, right? It says they shall acquire fields with money and write a document and sign, right? So it seems like, money is used to transfer land and a document goes along with it. So the Gemara answers, if it were written, they shall acquire fields with money at the end of the verse, it would be, as you said, that one must also write a document so that he can acquire the land with money. Now that it is written, they shall acquire at the beginning of the verse, this teaches that the money itself affects acquisition of the land, and the document is merely a proof. Rav says they taught that land can be acquired by means of money alone, i.e. without an accompanying document, only in a place where the custom is that they do not write documents. Such places, I would say, no longer exist. But in the ancient world, there were places where it was not the custom in a particular locale to write documents. It was enough that money changed hands and it was witnessed, right? How did Abraham purchase the field from Ephron that included the cave of Machpelah, where the patriarchs are buried? The money changed hands, but it was done in a formal ceremony in front of the tribal leaders. What there was not, at least not recorded in the book of Genesis, was some kind of a document recording that. Right? It was enough that it sort of entered the lore of the tribe because it was done publicly with the exchange of money. But, there was evolution, sort of legal evolution, even in the ancient world. And eventually it became standard practice, because there was more people in the world, more land deals going down, that they needed to record all of that. And so documents would accompany the purchase and sale of land. And certainly, fast forward 3,000 years, now you buy a piece of land, it's a lot of documents that are going to be part of that transaction. At any rate, right? So they say that documents were only needed in a place where the custom is that they write documents. And therefore, in such a place, one does not acquire land until a document is given to him. And if he specified that he wishes to acquire the land from the time of the money transfer, then he has specified his wishes and the land is acquired once the money is given, right? And so we're always separating, like in our minds, it's just so common to think, well, I paid the money, the object is mine, right? But the object doesn't become yours until there is this formal act of acquisition. And we're talking about there are different modes to complete that deal. It could be a gift or it could be a purchase and sale. But the formal acquisition, the transfer of that land or that movable property from one party to another doesn't happen until we have one of these formal modes of acquisition completed. Now, sometimes that could be the transfer of money in the presence of witnesses, but eventually by rabbinic law for land, unless it was a weird place where they just don't do documents, everywhere else, the document had to change hands also, right? And then there's also the symbolic exchange, the transfer of a handkerchief, or some other small object like that. There's going to be possession. There's going to be other formal modes of acquisition. But until that happens, even if the money has changed hands, the property has not changed hands, such that if the seller, has not yet transferred through formal acquisition the property to the buyer, if something happens to the property, the seller is responsible, right? Until the formal acquisition, the seller remains responsible for the property. Now, the Gemara comments, this is like that which Rav Idi bar Avin would do. When purchasing land, Rav Idi bar Avin would say, if I wish to acquire it by means of money, I will acquire it in that manner. And if I wish to acquire it by means of a document, I will acquire it in that method. He would stipulate at the outset that he reserves the right to choose how the transaction will be finalized. And the Gemara elaborates, if I wish to acquire by means of money, I will acquire it that way. And if you wish to retract your participation in the sale, you cannot retract it because we have agreed that the formal acquisition is at the moment of the money changing hands, right? We're using the money as the formal acquisition. If we don't specify that, then the fact that money has changed hands is not the formal acquisition. And if I wish, he would say, to acquire the land by means of a document, I will acquire it in that way. As if I wish to retract my participation in the sale, I can retract it provided that I have not yet received the document of purchase. The Mishna teaches that land can be purchased by means of a document. The Gemara asks, from where do we derive this? If we say that it is because it is written and write in a document and sign and witnesses shall testify from that same verse, Jeremiah 32:44, but didn't you say that the document mentioned in the verse is merely a document of proof? Rather, it is derived from a different verse in Jeremiah 32:11. And I took the deed of purchase, an expression that indicates that the document itself affects the acquisition. Shmuel said the sages taught that the document itself affects acquisition only in the case of a deed of a gift. But with regard to a sale, it does not affect acquisition until the buyer gives the seller money. The document itself does not affect the acquisition. Rav Hamnuna raises an objection, and he cites a baraisa. How is acquisition performed by means of a document if he wrote for him on paper or earthenware? Even though the paper or the earthenware is not itself worth 1 peruta, my field is sold to you, or my field is given to you as a gift. I'm saying if he wrote on the paper, even though the paper itself is not worth anything, it's not even worth a penny, but on the paper he wrote, my field is sold to you, or my field is given to you, and then he gives that paper to the buyer, that's the acquisition. That works. You don't need to have that the document itself is worth any money. It represents the exchange, and it is a valid mode of acquisition. So this indicates that a document is sufficient to effect acquisition, both in the case of a sale and in the case of a gift. And Rav Hamnuna raised the objection, and he resolved it. The baraisa is referring to one who sells his field due to its poor quality. The seller wants to be rid of his field due to its decreasing value and would like to transfer ownership of it as quickly as possible. In this case, writing a document is enough to complete the acquisition even before the money changes hands, right? The seller knows that the price is dropping. So he wants to make a deal and finalize it, even if the buyer is not yet ready to hand over the money, because he knows that if he waits another day, the price is going to be even lower. So he's willing to transfer the field now using the document as the mode of acquisition, even though the buyer will still owe him the money later. And so the acquisition is formalized with the document. So Rav Ashi says it can be claimed that the entire baraisa is referring to one case, that of a gift one wished to give another. The baraisa does not deal with a sale at all. And why does he write for him a deed for a gift containing the language of a sale? He does it in order to enhance his power. If it turns out that there was a lien on this land, and that the beneficiary, if it turns out that there was a lien on this land, the beneficiary can collect the value of the field from the giver's other property as though this land had been sold to him. In other words, by writing that it is a sale, the giver grants the beneficiary the acquisition power of a buyer. But since the transaction is actually a gift, the document itself completes the acquisition, right? So according to this interpretation of the baraisa, a document alone as a transfer to finalize acquisition only works in the case of a gift. Why might you use the language of sale in a document that creates a transfer of land for the purpose of a gift? So that the recipient of the gift will have greater power if it turns out that the land that he received as a gift could be seized from him by a creditor of the giver who says, you had no right to give away that land as a gift. You borrowed money from me and you pledged that land as collateral, right? As a guarantee for that loan. You didn't pay me back the money, so I'm seizing the land. And the fact that you gave it away to someone in the meantime doesn't affect my right to go and seize that land, because that land was liened to me as the lender. Now, the one who's giving the gift, right, in the language of the deed of gift, uses this language of sale rather than gift so that the recipient of the gift can now come and say, hey, you gave me a nice piece of land, thank you very much, but then your creditor came and seized it from me because he had a lien on it. I would like to take some of your other land to back up, to replace the gift that you gave me. Right now, maybe there was a gift, like, how does the recipient of a gift have the chutzpah to come and say, well, the land that you gave me was very nice, but it was taken away. Now give me other land. How does he have the chutzpah to say that? Well, because the gift might have been predicated on some other thing going on in the world between these people, like, well, I'll give you this land. if your son can marry my daughter, right? So it was not formalized in a document like that, but there was some kind of a quid pro quo, and so the recipient of the gift might say, well, then in the deed of gift you have to write some language that in case somebody comes and seizes that land from me, I have recourse to your other land. The Mishnah further teaches that land can be acquired by means of taking possession of it. And the Gemara asks, from where do we derive this? Chizkiah said that the verse states, Jeremiah 40:10, and dwell in your cities that you have taken. In what manner have you taken these cities? They are taken by dwelling, which indicates that taking possession of a plot of land and dwelling there is an act demonstrating ownership. And it is itself a valid act of acquisition. Sort of a squatter has rights, but this is, in the context of he bought the land and then he took possession of it, right? So there was no other formal act of acquisition, but that act of taking possession after paying for the land finalizes the acquisition. A sage from the school of Rabbi Yishmael taught a different proof. Quote, and you shall possess it and dwell there. Deuteronomy 11:31. How have you possessed it? You have done so by dwelling there. And this teaches that land can be acquired through an act that demonstrates ownership. Dwelling there, moving in. If it's just an empty piece of land, fencing it, right? So adjusting the land, creating some kind of physical transformation of the land, even of a very small degree, that shows that you have taken possession of it by dwelling there. The Mishnah teaches that property that does not serve as a guarantee can be acquired only by pulling. Now we're talking about movable property. And the Gemara asks, from where do we derive this? As it is written, Leviticus 25:14, and if you sell any item to your neighbor or buy from your neighbor's hand. And this verse speaks of an item that is acquired from hand to hand, like literally transferring the object from one hand to another, and we're calling this pulling. The Gemara asks, and according to the opinion of Rabbi Yochanan, who says that by Torah law, giving money affects acquisition, but pulling does not. Right, so the Rabbi Yochanan is disagreeing with the Mishnah. He's saying that for movable objects, the exchange of money changes, it creates the acquisition, but pulling by itself does not. What can be said? Rabbi Yochanan maintains that acquisition through pulling is a rabbinic decree. And by Torah law, movable property can be acquired only by means of giving money. Right, now, what does this mean? This distinction that we so often make between by rabbinic law versus by Torah law. What it means is that both laws are the law, but when it comes to Torah law, if there's a case of doubt, we rule stringently. If it's by rabbinic law and there's a case of doubt, we rule leniently. That's one important difference. Now, why does the Mishnah not mention this mode of acquisition? Why does the Mishnah not mention pulling? And the Gemara answers, Rabbi Yochanan could answer that the Tana teaches a rabbinic ordinance which reflects the accepted practice, but he does not find it necessary to mention a mode of acquisition that applies by Torah law. So the Mishnah further states that property that does not serve as a guarantee, i.e. movable property, can be acquired along with property that serves as a guarantee, like land. So the Gemara asks, from where is this matter derived? And Chizkiah said that the verse states 2 Chronicles 21:3, and their father gave them great gifts of silver and of gold and of precious things, which with fortified cities in Judah. Who's able to give a gift of a city or even multiple cities? A king. So in 2 Chronicles 21:3, we're talking about Yehoshaphat. I'm probably pronouncing that wrong. Yehoshaphat making a gift to his son Yeroham. This indicates that he gave his son who became king and the other sons movable items together with the cities. He did not need to give the items to them directly, as he was able to transfer these gifts by means of the cities that he gave them. Okay, so it sounds like he gave them the city and all the movable property that was contained in the city. So a dilemma was raised before the sages with regard to the matter of acquisition of movable property by way of land. Do we require that this movable property be actually piled on the land that is sold or not? Right, so if we're able to bundle an exchange of movable property with an exchange of land, do we require that that movable property be located on the land that it's being bundled with? That's the question. So Rav Yosef said, come and hear a proof from the following Mishna in Tractate Peah 3:6. Rabbi Akiva says the owner of any amount of land is obligated in Peah, that means leaving the corners for the poor, and in first fruits, bringing them to the temple at the beginning of the harvest. And if the debtor possesses land of any area, the creditor can write a document that prevents the sabbatical year from abrogating an outstanding debt for it. This is called a prosbul, so that his loans will not be canceled in the 7th year, and he can acquire property that does not serve as a guarantee along with it. And if you say that we require that movable and if you say that we require the movable property to be piled on the land, for what is land of any size fit? What can be piled on a tiny spot of land? Okay, a lot was said there, but we're borrowing a proof from this other area of the law, right? The fact that somebody who owns land, even if he's not the farmer who's farming it, he becomes obligated in certain responsibilities that a farmer would have, meaning that if he's going to harvest crops there, the corners have to be left for the poor. The first fruits have to be brought to the temple in Jerusalem when the temple is standing. And with regard to a prosbul, we've encountered this concept before, that the sabbatical year, every 7th year, right, when the temple is standing again, we do it this way. The sabbatical year cancels debts. So if somebody was to borrow money and then the end of the 7th year came, the debt would be canceled. Well, that sounds great, in a kind of idyllic state where, everybody has what they need. But in the real world where there's poor people, if that debt is going to be canceled at the end of the 7th year, then as the 7th year approaches, poor people will find it impossible to borrow money. So the sages instituted the concept of a prosbul, which meant that a lender could transfer the legal ownership of the loan and the rights as a creditor to the rabbinic court. And money that is owed to a court is not canceled by the 7th year. And in this method, using the prosbul, that the court can collect the debt for you, lenders would not have their debts canceled by the 7th year, which you'd think, well, that just protects the rich get richer, but actually it protects the poor because the poor can find money to borrow, even as the 7th year in the sabbatical cycle was approaching, again, when the temple was standing, and all these laws were in full effect. Now, why is this relevant here? The prosbul is relevant because one who was borrowing money where the prosbul mechanism was being used would have to have some collateral to put up when he's borrowing the money, and that collateral had to be land, real property. Prosbuls were actually only used when the borrower owned some amount of real property. Now, it doesn't have to be that he owns as much real property as the money that he's borrowing, but he has to have some real property to put up as collateral. Rav Shmuel bar Bizna interpreted it before Rav Yosef as follows. Now, we're still asking the question, if we're going to have a purchase and sale of movable property bundled with real property, does the movable property have to be located on the real property? And now we'll see why this teaching was brought in, right? Since the idea was, the Rabbi Akiva says, any amount of land, the owner of any amount of land, right? So is any amount of land going to be useful for putting movable property on it? I mean, if you have a piece of land that is 1 square amma, 1 square cubit, and I own such a piece of land that Nina gave me for my birthday, we own 1 square cubit in the land of Israel. So it's a piece of land approximately this big, right? Like, cubit, right? Yeah, it's like about like that. Like from the elbow to the finger, right? So the piece of property about this big, okay? So our piece of land is in Israel, and it's near Mount Carmel or on Mount Carmel. And we own 1 square cubit. Now, what can you do with that? You can't pile much movable property on 1 square cubit. But if you could bundle movable property with real property, and the movable property doesn't need to be piled on the actual piece of land, well, then that square cubit could be very useful, right? Very useful. Rav Shmuel bar Bizna interpreted it before Rav Yosef as follows. For example, if one stuck a needle into a tiny patch of land, which he sold by means of the land, well, the needle is acquired. In other words, you could use the modes of acquisition that are available for acquiring land and are not available for movable property if you bundle the movable property with the land, right? So the needle in this case is the movable property, and the amount of land that could contain a needle stuck in the ground, well, this is a really tiny piece of land, but it would work. Rav Yosef said to Rav Shmuel bar Bizna, "You disgust me." Pretty strong language. Says Rav Steinsaltz, well, according to the Geonim, this term means you caused me to be disgusted. The root kuf bet samech refers to gorging on food to the point of vomiting. Some commentaries explain that this word is a noun and means one who bothers or angers others. And yet others suggest that it is derived from the Greek kubistes, which means one standing with his head down. And in this context is referring to one who utters strange and contrary ideas. At any rate, it seems like Rav Yosef was saying, you're mocking us. You're talking about a piece of land so small that it contains just a needle. Like, what is the point of having this discussion? So Rav Yosef said to him, you disgust me. Did the Tana of our Mishna go to all this trouble just to teach us that a needle can be acquired by means of land? And Rav Ashi said, wait a minute. Don't be so quick to dismiss this idea. Who shall say to us that he did not hang a pearl worth 1,000 dinars on that needle? So one can acquire an item of high value through land of such a tiny size. In any event, the question of whether or not the movable property must be piled onto the land has not yet been resolved. Comment here, as Rabbi Elazar said, there was an incident involving a certain Madonite, a Madoni, who was in Jerusalem, as he had a great deal of movable property, and he wished to give it as a gift. He was ill, and he did not have time for the recipient to acquire the property by pulling. So the sages said to him, now we see why it's important to be able to bundle movable property with land. If the only way that you can transfer movable property is by actually taking hold of it, and there's a lot of movable property, and we're in a hurry, and there's not going to be a way for the buyer to actually take hold of all that movable property, it would be great if we could bundle it with just some tiny piece of land, which could be exchanged just through a document, right? And it could be done very fast. So that's what they were trying to do. He was ill. He did not have time for the recipient to acquire all that movable property by pulling. So the sages said to him, one in this situation has no remedy but to transfer all that movable property by means of land. So what did he do? He went and acquired a beit sela, apparently meaning land the size of a sela coin, very small piece of land, near Jerusalem. And he said, this northern portion of the beit sela, so not even the whole piece of land the size of a coin, but the northern portion of it, is given to so-and-so, and with it 100 sheep and 100 barrels of wine. And the Madoni died, and the sages fulfilled his statement and gave the gifts. So we see from this incident, it would appear that movable property can be bundled even with a very small piece of land, and the movable property does not have to be located on that piece of land. And if you say that to acquire movable property by way of land, we require that the property be actually piled upon it, well, for what is a beit selah fit, this land that's the size of a coin? It is impossible to pile 100 sheep and 100 barrels on top of such a small plot of land. Right? Not only are we saying that the movable property does not have to be physically on that piece of land, but we're also saying that that piece of land doesn't even have to be capable of holding the movable property. We might have said, well, we could bundle it with a piece of land that even if it's not on that land, but the land has to be big enough to contain the movable property. But we're saying, no, we don't need either one. It doesn't have to actually be there, and the land doesn't have to be big enough to hold it if it were there. Yes. So the Gemara rejects this argument. Do you maintain that a beit selah is referring to a place that is actually the size of a selah coin? No, you misunderstood the story. When the sages told this dying man to give his movable property by way of a piece of land, and he purchased a beit selah for that purpose, he wasn't talking about a piece of land the size of a coin. Rather, what is the meaning of the term selah? It is referring to a place that is very large and that could hold the many gifts. If that is true, why did they call it selah? This name indicates that it was as hard as rock. Not selah meaning a coin, but selah meaning rock. Come in here a proof from a different source. As Rav Yehuda says that Rav says, there was an incident involving a certain person who became sick in Jerusalem. And the assumption that he became sick is in accordance with the opinion of Rabbi Eliezer, who says that a person on his deathbed can transfer property only by means of an accepted standard act of acquisition. And some say he was healthy. And that assumption is in accordance with the opinion of the rabbis that a person on his deathbed can transfer property by means of speech alone, whereas a healthy person requires an accepted act of acquisition. So, a little bit of argumentation over exactly what happened in this story, but what they're saying is they used a standard act of acquisition, not speech alone, which is available according to some opinions for people on their deathbed, but not in the normal course of affairs. So what was the incident? This man who got sick, at least, or he wasn't sick, but anyway, he's going to use a standard act of acquisition. This man had a great deal of movable property, and he wished to give it away as a gift. And the sages said to him, in this situation, one has no remedy but to transfer movable property by means of land. So what did he do? He went and acquired land the size of a Beit Rova near Jerusalem. And he said, this square handbreadth is given to so-and-so. So a piece of land 4 inches by 4 inches. And it's given to so-and-so. And with it, 100 sheep and 100 barrels of wine. And he died. And the sages fulfilled his statement. So it's the same story, except it's not a coin-sized land, but a handbreadth-sized land. But again, a piece of land so tiny, there's no way it could contain 100 sheep and 100 barrels of wine. So this would seem to prove that you can bundle movable property with a transfer of land, even though the movable property is not on the piece of land, and even though the piece of land is so small that it couldn't contain all that movable property, even if it was there. And the Gemara rejects this. With what are we dealing here? It is with money. He sought to give the value of the barrels and sheep. And money of this amount can be placed on a small plot of land. And the Gemara comments, so too, it is reasonable that this incident involved money, as if it enters your mind to say that it involved an actual group of 100 sheep and 100 barrels, let him transfer them to the recipient through an act of symbolic exchange. If the incident involved money, which cannot be transferred by symbolic exchange, he had no recourse but to acquire land. But didn't the sages say to him, you have no remedy but to do it this way, right? And if you could say that you could transfer these movable property like sheep and barrels by means of a symbolic exchange, why did they say to him, you have no remedy but to bundle it with land? Let's keep reading. The Gemara raises difficulty against this argument. Rather, what will you say? That this is referring to money, which cannot be acquired through symbolic exchange? Even so, he still could have acted differently. Let him transfer it to the recipient through pulling. Rather, you are forced to say that the recipient of this gift was not present, and the man wanted to grant him possession of it without the recipient having to perform a physical act of acquisition. So too, it is possible that the recipient of the gift was not present, and he was unable to transfer it to him through symbolic exchange. Consequently, there is no proof that the incident involved money. So the Gemara asks, and we're almost done for today, so questions or comments, please get them in. The Gemara asks, is there no other way to perform this acquisition but let him transfer it to him by means of another person? I.e., another person can pull the property on behalf of the recipient. And the Gemara answers, the giver did not rely on that option, as he feared that the third person, the third party, might seize the movable property and consume it, or use the property in some other manner. The giver wanted to be sure that the acquisition would be completed in full, not to some intermediary who seized it himself, or not through some intermediary who might abuse it in some way, but that the recipient, the intended recipient, would get all of it. So rather, what then is the meaning of the statement, he has no remedy, that the sages said about this person trying to give all this movable property? Even if he did not want to use the option of a third party, it was certainly available to him. So the Gemara explains that this is what Rav was saying and meant in his description of this incident. In accordance with his decision that he does not rely on another person and does not want to transfer property by means of anyone else, in this situation, one has no remedy but to transfer movable property by means of land. In summary, no decisive proof has been cited as to whether or not it is possible to acquire movable property by means of land when the items are not piled upon the land. We have not yet resolved the question. Tune in tomorrow night after Shabbos ends to see if we resolve the question then and how we resolve it. Okay, let me take a couple of questions on Kiddushin 26. New flavor of LaCroix. Pastek. Watermelon flavor. Not bad. Sharon. But doesn't the Torah tell us that even in good times, there will always be poor among us? Why did the Torah make this allowance and the rabbis had to do this? Great question. So Sharon is asking, why was it necessary for the rabbis to come up with a mechanism to assure that there would be money, that lenders would be, would make loans to poor people as the seventh year was approaching, when the Shemitah cycle was being observed in Israel, when the temple was standing? If the Torah told us already that there would always be poor people, right? So there was always going to be borrowers, right? There was always going to be people who needed to borrow money. So why would the Torah create a system where all debts are canceled in the seventh year, and then, poor people can't borrow money, and then the sages would have to come up with a system to, deal with that? Like, why did the Torah, not come up with the system itself? Or why did the Torah cancel? Why did God, see fit to say that all debts are canceled every 7 years, even though this would create that liquidity problem for poor people? So I'm just speculating. I don't know the answer. But I would say that one possible answer is that God gave the core of the oral law to Moses at Sinai, with the understanding that here's a few laws that are given orally, and that you will teach to Joshua, and Joshua will teach to the elders, and the elders will teach to the men of the Great Assembly, and the men of the Great Assembly will teach to the rabbis, etc. And that core of the oral law would mean that the Torah as a whole, which is a combination of the written law and the oral law, would remain supple and flexible and able to deal with situations as they arose. And maybe there would always be poor people, but there was a larger number of poor people in later generations that really required this to happen. And maybe God always intended that there would be a partnership between, God and then Moses, Joshua, the elders, etc. The elders in every generation, the sages entrusted with interpreting the law and creating rabbinic decrees in the generations, that partnership was always intended, right? And so really, it's not like the sages were just inventing something out of thin air. They were always basing it in Torah law, and God, who sees everything, past, present, and future, intended it for it to work that way. That's at least one possible answer. And Sharon also says, my grandfather is buried on Mount Carmel. Does that make my family landowners there as well? I don't know. I mean, I guess when you buy a plot in a cemetery, you pay money for it. So what are you buying? Are you just getting the right to bury your dead in that land that's owned by the cemetery owners? Or have they actually ceded to you the plot? I don't know the answer to that question. So I can't answer, but it's a great question. What I do know is that Nina got this for me, and I guess if you Google, it's probably anybody can do it. It doesn't cost a lot of money, but you get a little certificate that says you own 1 square cubit in Israel, and then you get you can frame the certificate. So it's a great gift for anybody. That's what I've got for us today, and with God's help, after Shabbos, we'll be together again tomorrow night. It's getting earlier and earlier, so it's getting more and more reasonable. I'll try to get on the air before 9 p.m. tomorrow night, if at all possible. I mean, it's always tough after Shabbos. We daven at shul. I get home. We do Havdalah. Nina and I do a little reading for the conclusion of Havdalah, and then we get on the air. At any rate, have a great Shabbos.